All right, welcome people, welcome. We will start at probably a little after one, a minute or so after one, just because I don't see as many participants as we were expecting. So give it a minute or two, and then we'll get this show on the road. Elizabeth, if you were, I don't know if the number helps on this, but the M1 number used to be the NRDS number. It's the same concept. They just renamed it as an M1. But whenever someone would talk about your nerds number, that was what they were referencing. All right, we'll start up in about a minute. Let's give it one more minute. All right, 1 minute is passed. Let's get this show on the road. So, my name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors, one of the people that works with the forms. This is the August 2024 updates to the Oregon Realtors forms training. This is essentially update 2024-2. We had one update that we brought out at the start of 2024 that added some stuff, it subtracted some stuff. This is the second update of the year and is largely in response to the Sitzer-Burnett trial and the various settlements that have resulted from that. So, this is essentially what our roadmap is for this training. We're going to begin with, we're going to talk about major updates to the forms. Specifically, there have been major updates to 1.1 through 1.5, the sales agreements, to 2.10, that's the contingent right to purchase form. We have removed our documents 2.24 and 9.10. We'll talk about the listing agreement, we'll talk about buyer representation agreements, and we'll talk about the new 9.3A and 9.4A. They're amendments that are sort of directly attached to the listing and the buyer representation agreement. As you see on the left-hand side of the page, these 2024-2 updates are the result of several various sources. They're from user comments. Yes, we listen to your comments. Yes, we read them. Yes, we respond to them when we can. To the national settlement that happened with the Sitzer-Burnett lawsuit in Missouri, as well as the passage of House Bill 4058, input from our forms task force, and review by the attorneys for various things that we determined needed to be changed. That's the minor changes that we'll talk about are essentially the attorneys thought it was a good idea to make the change. There are various minor changes, so very minor updates to the seller and buyer occupancy forms, minor updates to the investment property addendum, to the tenant vacancy addendum, and to the agricultural tenant addendum, minor updates to the notice of termination and the response to termination, minor updates to the buyer and seller advisory and to the non-agency addendums, or the non-agency agreements rather. Those minor updates, we'll cover all of those as well. Each one of those is kind of 2 or 3 forms that are all bundled together. They have like one sentence change that is added to it, or like a single word that is added to that document that does make technically an impact. And then there were some minor fixes. It was quality of life changes, typos, and etc. that were modified. That change is made to all of the forms that you see here, as well as the ones that we talk about in the minor and the major updates. So a couple quality of life shifts that we've put into the forms, a couple things that are the typos that we've updated. So like the word addendum wasn't capitalized when referring to a specific thing. It's a proper noun, so we capitalized it. But we'll talk about all of these changes. We'll have a slide for basically every one of the changes. And when I can, I bundle the changes into one place. If it's the same change made to multiple documents, we're not going to have a slide for each one of those. It's just one slide that shows comprehensively what the change is to many of the documents. If you have questions throughout, the chat is open as well as the Q&A. Q&A stays pinned, so I will see the question the whole time in the chat. If it does turn into something where people start just rattling comments back and forth, I will potentially lose your question in the shuffle. So Q&A is always the place where we advise you put the commentary, but either one is available to you, and we welcome any commentary or questions that you have throughout the process. I am particularly bad about pausing in the middle of things and responding to questions, so be aware this could be a relatively stilted training. As questions roll in, I will try and answer them, but we'll try and roll our way through the training as we go. We're supposed to be here for an hour, and that's what we've got. We're going to start with talking about the major updates. This is made to all of the sales agreements, 1.1 through 1.5. That is the residential purchase and sale agreement, the commercial purchase and sale agreement, the manufactured and floating home purchase and sale agreement, the agricultural property purchase and sale agreement, and the vacant land purchase and sale agreement. The same change has been made to each of these documents. A new section has been added to the financial terms provision. The financial terms is section 4 of the 1.1. It's section 4 of most of the documents. I think it's section 6 in commercial and section 6 in agricultural. I'm not 100% on which one that is, but this same change has been made to the financial terms section of those various documents. Specifically, 4F has been added, 4G, 4H, 4I. 4F is a little checkbox that you have an option to say the seller is to pay buyer's broker fees to buyer's agent firm at closing in the amount of a certain number. That was previously accomplished with Form 2.24. We essentially had a separate addendum that allowed the seller to make a direct payment to pay for the buyer's broker if they wanted to. That's now just been integrated into the purchase and sale agreement, so we can jettison 2.24. You no longer need the addendum. It's just in the sales agreement itself. 4G is a little asterisk thing that's a checkbox that says the seller's agent firm has separately agreed to pay the buyer's brokerage fee in the amount of blank. It can be a flat number or a percentage. That is what has previously been known as the cooperative compensation. It is a little asterisk, is this line 2829. Line 4G is for informational purposes only, and the references to an agreement between the brokerages is not a part of this agreement. The buyer attests to the total on line 4H. We'll get to that next, but essentially this 4G thing does not establish the compensation between two brokerages. That has to be established between the brokerages. When you do cooperative compensation, it is an agreement between the buyer's agent brokerage and the seller's agent brokerage. It is not something between the buyer and the seller. Your sales agreements are only agreements between buyer and seller. The privity between contract there is only between the buyer individual and the seller individual. The brokerages have no technical part as a party to that sales agreement. So if you in the sales agreement say the seller's agent firm agrees to do the following things with the buyer's agent firm, the seller and the buyer's agent's firms have not signed that document as parties to the contract. In the same way that I could sign an agreement with you that says Bill Gates will pay me $1 million, we can both sign the document, but it's not binding upon Bill Gates. It just isn't going to happen unless he agrees to it himself. And so in the same way, your contract, your sales agreement, it does not create obligations between the parties. It's merely informational. The informational portion there is important. We're going to cover all of these with a little more close clarity on this. We'll start with 4F. Parties can now specify payment to the buyer's broker fees within the sales agreement. Used to be in 2.24. Our task force did find that this is something that we best accomplished in the sales agreement rather than in an addendum. It does put it front and center, makes it more clear and more kind of obvious, which then is in line with the requirements of this Sitzer-Burnett settlement. In essence, the Sitzer-Burnett settlement requires that if you do have a situation where the seller is paying the buyer's broker some amount directly, basically the seller is providing a concession of some sort that is then being used to pay the buyer's agent, that be front and center in the document itself. It be something that is readily found and not an addendum that is attached at the back of the document. And so we have it now on the first page. Section 4G, broker-to-broker compensation. As I was saying earlier, it still can be utilized. It can be disclosed in this section. The asterisk does note it is not binding on the other, on the agents themselves. Rather, it is a disclosure. It is information. The information has to be there essentially because you do need to know how much that the buyer's broker is receiving from the seller's broker in order to ensure that you do not pay above what it says in your buyer's representation agreement. That would be something else that violates the settlement, and that's part of the reason why this section 4H is there. 4H should be the total compensation paid to the buyer's agent as a part of this contract. Basically, how much is the seller paying the buyer's agent? How much is the seller's agent paying the buyer's agent? When you put those two things together, it should be equal to or less than the amount that is agreed to in your buyer representation agreement. Per the settlement, the buyer's agent should not be receiving a larger amount of money than is agreed to in their buyer rep agreement. So I'm going to use little low numbers so it doesn't seem like I'm just trying to fix a compensation. Let's say you're a buyer's agent and you agree to get $10 from your buyer. If the seller is offering to pay you $6 and the seller's agent is offering to pay you $6, that collectively would be $12, which puts you more than the $10 you were supposed to get from your buyer. That is not okay as a part of the settlement to stay kind of under the umbrella, the protective umbrella of the Sitzer-Burnett settlement that NAR formed with the various plaintiffs in that case. You would have to, as a buyer's agent, you would only receive a maximum of what is in your buyer rep agreement. So $10, what you agreed to in the beginning part, is the only amount you can receive in the end. And so that line 4H should be representative. If you are a buyer who is, or a buyer's agent who is filling out an offer, that line 4H should not be a larger sum than what you have already in your buyer representation agreement. You should know that that is the number is equal to or less than. In theory, if we work with the platforms that do these forms properly and they do it the way we would like them to, what we're going to be asking them to do, there should be an automatic calculation that is done where the zip forms and the sky slopes of the world, it will automatically take whatever you've entered into on 4F and whatever you've entered into on 4G, and it'll add those two things together and provide a comprehensive answer on 4H. You should have some answer at the end of that process. Technically, there is no like we don't have a process in this at this stage for if the seller is agreeing to pay a percentage and the agent is paying a flat fee, or if there's some mixture therein. And so there is going to be some kind of input, some calculation and tabulation that the buyer's agent should be doing when they fill this out. They should make sure that 4H is at least representative of, at most, the amount on the buyer rep agreement. And then lastly, that part that is in the line 27, 4I. 4I is just the amount of other closing costs that are not a payment to the buyer's agent that's going to be part of this transaction. So if you're a seller and you agree that you're going to pay the buyer's agent, $600 and you're also going to provide a $300 carpet cleaning deposit, that sort of thing. At that point, you would put that $300 that is the carpet cleaning deposit, that would be in line 4I, because it is a not paying the buyer's agent closing prepaid cost that the seller is providing. So in the end, what you should end up having on these lines 4F through 4I is a comprehensive explanation of all of the various payments that are going to waylay some cost that the buyer would have otherwise expected to pay. That's the major change. It has been made to 1.1 through 1.5. That's the significant change. Technically, we also make reference to these sections throughout the contract as well. And so I believe in the closing costs section, we do make a reference back up to section 4, this 4F through 4H situation. So there is one other reference to this line, section 4 something or other, in the later in the contract, but this is the major change, is this new structure for explaining compensation either through the buyer, the seller's agent, or through the seller themselves. Corinne asks in the chat, when will these changes be implemented? We're working with the platforms presently. It's looking like it's going to be either July 29th or sometime in early August. Presumably early August is what we're going to be shooting for, but they should be in place before the August 17th drop dead date that NAR has provided on MLS rule changes. In essence, it should be really soon, but we are also getting really cagey responses from the platforms where they're saying something to the effect of, everybody's changing their forms because of this settlement, and it's so hard to get this stuff done on time, so please give us as much time as you can. And we're working with them on that, and the question is, do we twist the thumb screw or not and give them a little more time, or do we hold them steady to a July 29th date? Stay tuned. We'll be able to provide much more accurate information on when we have an exact statement from the platforms on when they will make these changes to the forms. 2.10 also underwent a significant shift. So this is the contingent right to purchase document. If you've been using the 2.10, it is designed to essentially set up a special acceptance right. It's a buyer who has a sketchy set of financing. The buyer basically says, seller, I want to buy your house, but I don't have enough money yet. I have to sell my house first, and then I'll be flush with cash and I can buy your house, seller. No problem. This has been kind of a pretty standard thing in the industry for quite a while, but what we've added is this lines 20 down through line 30. This is the new addition. We'll start with talking about kind of how it previously has been. If you have any, like the traditional, the past way of doing this is when you sign your contingent right to purchase, the buyer can indicate that I'm currently listing my property or I will list it soon. I'm going to sell my house. I'm going to advertise it. I am going to make my property available and I'm going to try and get this thing done so I have the money to purchase your house when I promise to purchase it, seller. So you can still do that. The buyer can still say, my house is currently listed. Gosh, I hope I get an offer on it. Or my house will be listed soon. Gosh, I hope I get an offer on it. The buyer can still do those things. If either of those is selected, congratulations, proceed with this under a contingency. You've got the contingency deadlines and all that stuff going on. What the addition does is it addresses a situation that we got quite a few comments about from people over the last year or so, where they said, what if I have a contingency where my buyer wants to buy the seller's house, but their property is already under contract? So the buyer's not saying, seller, I want to buy your house, and gosh, I hope enough money I have enough money to do it when I get to that point at closing. Instead, the buyer is saying, seller, I want to buy your house, and my house is already under contract. It's very clearly going to sell. I am so excited. The traditional approach to how you would address that with the contingent right to purchase form would have been you send a contingent right to purchase and you simultaneously provide a notice of intent that says, I'm already under contract. And then that would then create kind of this additional right where the buyer is supposed to keep the seller appraised of how their sale is going. And if things go wrong, there's a termination right. That was unwieldy, making it something where you'd have to provide a document that says, gosh, I hope I'm going to sell my house in the future. Also, I'm already selling my house. It felt contradictory. And so what we have instead is this line 20 through 30 section that's been added. You can check the box which says, my property currently has an accepted offer on it and is under contract with a closing date of the following day. Buyer's accepted offer is or is not currently subject to a contingent right to purchase some third party that also has a contingent right. So you'd specify that stuff. And if this is selected, the buyer is agreeing that they'll keep the seller informed of all material changes that relate to the buyer's ability to close the sales agreement. They will, the other sections of the agreement that relate to like a contingency deadline and the seller being able to send a contingent right to purchase document in that says, I accepted another offer on my property. You can keep the house, in a weird bumpable phase. Essentially, the seller will just shift the property over to pending, but we have pending with kind of a sketchy buyer financing going on. The buyer will promptly notify the seller in writing if there's an offer on the buyer's property. If the offer is terminated for whatever reason prior to the closing date that they expected. And after receiving that notice from the buyer, the parties can terminate the contract or they can negotiate some sort of a procedure for moving forward. If they don't negotiate a procedure, then anybody can present a notice of termination. This lines 22 through lines 30, this is exactly what happens in the contingent right to purchase's notice of intent. If you say, I got an offer accepted on my house, I, buyer, have someone who wants to buy my buyer house, which will give you the finances required to buy your seller house. This essentially just mainlines it into the contingent right to purchase. So where previously there would be an additional document, they've now just been integrated into the same singular document. And if you check the box on line 20, it's as though you've already sent in your notice of intent with that thing that you say, I want to keep going, I'm under contract, it's great. It's all now in the same single document. In theory, this should make it much more straightforward for those situations where when you have a buyer who wants to purchase a seller's house and is already in the process of selling the buyer's house. They don't have to do this awkward two-step. It's a one-step process now. Form 2.24 was removed. Form 9.10 also removed. If you thought back, if you're like critically aware of what those forms are, then that might be a major change. If you haven't seen those forms yet, I'll talk through what they do. 2.24 previously was the seller's payment to buyer's broker addendum. It was basically a way for the seller to say, buyer, here is some money. You can only use it on your agent. And you would put that addendum on your document, and it would then make that a part of your agreement. It would essentially be a concession that's baked into the contract. It's not an interested party contribution, which is where Fannie Mae and Freddie Mac create these limitations on it, but it was arguably by definition a concession, although not an IPC, and so limits didn't apply. That Form 2.24 was essentially like, it's the DOJ's suggestion from MLS PIN versus No Select, that they say you should really separate your commission process. The buyer pays the buyer's agent, the seller pays the seller's agent. If the seller does so choose, through the offer, they can also offer to pay for the buyer's agent, but it shouldn't be something that's just baked in. It shouldn't be something that is an upfront process. So by putting 2.24 allowed you to do that process without kind of making the DOJ angry and not doing cooperative compensation. It was not provided through the MLS. It wasn't split off of the seller agent's commission. It was the seller making a concession payment to the buyer's agent. That was previously done on a separate form. Now it's in the sales agreement, so you don't need it. It's not required. 2.24 is gone. We've removed the form. Similarly, 9.10 was also kind of a post-settlement bandage form to sort of address the way that we would move forward after the settlement. 9.10 was the brokerage-to-brokerage cooperative compensation agreement. It was the way of establishing cooperative compensation. Our task force, our forms task force, they made a determination that we are going to move away from facilitating upfront offers of compensation. That is a situation where basically before the buyer even sends their offer in, you, the seller, have provided an explanation of the amounts that you are willing to pay. That's an upfront offer of compensation. The reason why we're moving away from that per the task force is essentially that was part of the core of the Sitzer-Burnett lawsuits. It was pre-establishing a number, and then buyer's agents would cleave towards that number. We're removing upfront offers of compensation as a concept from the Oregon Realtors form library, sort of in anticipation of what the future may bring. As a result of moving upfront offers of compensation, the task force determined that it was really not the Oregon Realtors form's place to facilitate brokerage to brokerage compensation. That is something that still is technically allowed under the settlement terms, but it's something that would either be dependent on the parties themselves or on the MLS permitting it. For example, Northwest MLS up in Washington, they are spitting in the wind and deciding to ignore the settlement itself and basically just rolling with business as usual as it had been before. What that means is there will still be technically what appears to be some sort of a version of cooperative compensation that or upfront offers that is in the Northwest MLS process. Theoretically, MLSs in Oregon could do the same thing, which means cooperative compensation is not necessarily gone, but Oregon Realtors forms will not be facilitating it. If you still want to do a brokerage-to-brokerage cooperative compensation of some sort, you can have a private document drafted for your brokerage that you can utilize with the other brokerage, or the MLS may be providing that document if they take the bent that Northwest MLS has taken. But the state association isn't really the place to provide that. So we've also iced Form 9.10. It's not there anymore. The listing agreement has undergone a significant change. This is basically what we're talking about. The upfront offer of compensation is no longer something facilitated through the listing agreement. At most, what we can do with the listing agreement now in the seller contributions to the buyer section is you can check this little box on line 54 through 55, which says the agent is authorized to communicate seller's willingness to consider buyer offers that contain a request for seller contributions towards the buyer broker fees. Functionally, what that means is you're not going to be, through the listing agreement on Oregon Realtors Library, you will not be advertising cooperative compensation. You will not be advertising how much the seller is offering or how much they are willing to offer. That upfront process has been excised. Instead, at most, what we can do is we can say, agent, please talk to the buyer and let them know I am open for business. I would love to see their offer. Put your best offer out in front of me. If I like it, we're under contract potentially. If I don't like it, I can counteroffer. But it isn't something where the seller pre-games it, where the seller doesn't prime the pump and say, I'm willing to offer X number of dollars. Put it in your offer. Because at that stage, you would have a seller, arguably per Missouri's lawsuit in Sitzer-Burnett, fixing the amount of money the buyer agent or the buyer is offering. And so what we've done instead is we've just kind of booted it out and said you can authorize willingness to see offers from the buyer, but we don't do anything beyond that. Beyond that, there is another change that's been made to the listing agreement. We have a little section in here where you can check a box, and it will allow you to modify the compensation structure if you have an unrepresented party. The expectation is into the world we're wandering into after this settlement, after Sitzer-Burnett, after all of the stuff that's been going on, you may see potentially more unrepresented parties. It is going to potentially be a more common thing. As a result, expecting potentially more unrepresented parties, we put this lines 36 through 37 in the listing agreement, which says, even though on line 35 it says my brokerage fee is the following percentage of the gross sales price or a flat number, if we're in an unrepresented party situation, it's going to be a different number. Now that may be something where you say, if it's an unrepresented party situation, it makes my job so much easier because I don't have to handle, Jim down the road who's the other realtor in town, and that's so much easier for me. So I'm going to take a lesser amount of money. Or it could be something where you say, if it's an unrepresented party situation, I am doing double the legwork, so it should be a larger number. But in the end, you're allowed to modify your compensation based on whether or not it is a represented or an unrepresented party. The idea behind this is to give some flexibility and make it so that there need to be fewer addendums that kind of smack onto the listing agreement after the fact. And it's something where at the beginning, you and the seller can agree to these values and these numbers with kind of your eyes wide open, understanding the potential situations that could arise. Other ad that we did on this is not related to the Sitzer-Burnett lawsuits, but we have a section in the listing agreement that is the early termination fee. Basically, if you can both mutually terminate the agreement, that's fine. If you and the client agree to terminate the contract, it's over, it's done. If the client just suddenly terminates the contract on you unilaterally without mutuality involved, they just say, I'm done now. There is an early termination fee happening before the end of the term. The concept behind this is essentially to stave off the situations where a client terminates their agent solely to avoid paying compensation. It is functionally the same situation that exists with procuring cause arguments, because the client could always just run this out to the end of the term and just not sell their house to anyone. So if they're terminating early, there's potentially a malign reason for it. As a result, we had checkboxes for early termination fees. It was originally a checkbox for 25% of the expected brokerage fee, or a flat number equal to that was representative of your reasonable expenses and costs. We've added a checkbox in there, which is check the cost of all marketing expenses broker incurs while marketing the property up to the date of the early termination, as evidenced by receipts that are promptly provided to the seller after the early termination occurs, which basically means you can lock this in as whatever I have expended on your transaction, if I can prove it, that's the early termination fee. I want a refund of the expenses I spent in setting up the house, getting it arranged properly, of doing the photographs, of all that stuff. Seller, you're on the hook for my expenses. That's our early termination fee, is my expenses. Put me back where I started. Now, this does require an additional step of you being able to prove with receipts what you have expended. So make sure you keep your receipts. But alternately, what this allows you to do is say, look, seller, if this seems too squishy, if this is an uncertain number and you're not comfortable with it just being receipts and things like that, we can set a flat number, a flat percentage or a flat number, and that will be a much more kind of liquidated damages answer. If it's an uncertain amount, we can set a liquid damages, and this first checkbox implies that. I see a question there that why use gross sales price versus net sales price? Gross sales price was what was essentially pressed for in our task force. So it was the determination of the task force is that was the better number to figure these things out. The exact reasoning for it, I believe, was more based in the fact that seller concessions and concessions in general can sometimes finagle the numbers in awkward ways, whereas the gross sales price was typically kind of a more comprehensive or a more clean number. In the end, it was the task force determination. The lawyers were completely agnostic on that one. Beyond Form 9.3, which is the listing agreement, there is a new form, 9.3a. This is the settlement amendment to the listing agreement. Now, this document will only be in the library for a little while because the settlement is only going to be impactful upon present transactions for a little while. But the whole purpose of this one, the point, is that it allows you to render pre-rule change, pre-settlement rule change listing agreements into compliance with the terms of the settlement. The purpose as written reads, I see a Q&A. Sorry, I'll go back to the Q&A. Why is that 25% as a default? The blank would be better. Technically, there is no default. I'll go back to this one to show. They are all checkboxes, so there is no technical default number. The reason why 25% is there is because it's a pre-established number. If you have the default being a write in the blank, it's not actually a default at that stage. The blank is user input. And so if you're going to check the default being write something in, so in this instance, you don't have to check a box. You can always just not check a box, and then there's no early termination fee, or check that last one and say $0, which implies that it is a $0 early termination fee. But generally, if with this sort of a concept, the default being something that is just all blanks, I'll duly noted, David, on the comment that all blanks would be better. We originally had just a flat 25, and the request was for a blank. But equally, parties have requested having a flat number that is not a blank, largely because it makes it easier to explain why the number exists as a liquid damages fee, rather than if you write in a number, you run the risk of violating what's called D. Tomasi versus Moak Realty. It was a case from the, I believe, early 80s, where the real estate agent was brought to task on a fee like this that was essentially, it was too large a number and was therefore found to be a punishment, a penalty, rather than a liquid damages sum. Something that in the range of 25% is within a liquid damages sum range, but it's essentially, if you put in a blank and somebody says $1 million, that's not legal at all. It's super illegal. And so we put in a blank to essentially allow the strictest and the fastest route to a legally valid approach, rather than just saying, like, we trust you guys understand the law well enough to write the right number in there. So it provides both options rather than just one, but that's ultimately the reason why there are multiple options, is because there is legal precedence on liquid damages that does get troubling if someone puts too large a number in, and when you leave a blank, too large a number can be selected. So 9.1a or 9.3a, the purpose of this document is as a result of the proposed settlement agreement that was entered in March of 2024 between National Association of Realtors and the plaintiffs in the Missouri and Illinois lawsuits, Sitzer Burnett, that kind of thing. Certain practice changes will be implemented by multiple listing services and multiple listing users effective August 24th or 2024. The exclusive agency relationship between the seller and the agent, the listing agreement that predates the effective MLS rule changes, therefore requires modification to set the listing agreement into compliance with that settlement. Upon mutual acceptance of this agreement by the seller and the agent, the terms of the amendment are then made part of the listing agreement. If there's a provision in this amendment that conflicts with a term in your listing, this amendment controls. Everything that's not conflicting with this amendment stays the same. Basically, what it says is overwrite all the stuff that's not in compliance with the settlement and instead put in this language, which is in compliance with the settlement. It is a way to backtrack compliance into listings that were written before the settlement took effect. There are some arguments that the pre-settlement effect listing agreements are technically still valid, but if you're concerned about that, if you don't want to roll the dice on seeing how ex post facto works in the world of real estate rules and MLS rules, this is the document you can use. The language modification is almost verbatim drawn from Section 58 of the settlement. It just has the things that are changing in your listing agreements. The broker won't disclose or make any offers of compensation to buyers or brokers or other buyer representatives directly or through the buyer on the MLS. They won't disclose the total compensation or the listing broker compensation on the MLS. All references to offers of compensation to buyer brokers and buyer representatives will be removed from the MLS. The broker will also provide offers of will be able to provide offers of compensation to the buyer's broker or buyer representative, but can only do so off the MLS. The broker shall effectuate any broker offer of compensation to a buyer broker or other buyer representative through a separate agreement between that firm and the buyer representative's firm. Prior to providing any payment or prior to any agreement to pay another broker acting for the buyer, the broker shall conspicuously disclose the amount or rate of such payment in writing to the seller seller and shall obtain the seller's approval for such payment or offer of payment, and the seller and the broker agree and acknowledge that the broker's commission is not set by law and remains fully negotiable. These are almost carbon copy quotes from the settlement. If you're modifying your agreement to carbon copy quote the settlement, it's very hard for someone to argue you're not in compliance with the settlement. That's why this form exists. Is essentially there's going to be a short single generation of forms that are going to be somewhat out of compliance. The agreements, the listings that were drafted in July that were valid until December of this year, those listing agreements are going to have a problem that maybe the settlement kicks their terms out of compliance with the MLS rules. This allows you to kick it back into compliance. The buyer representation agreement has also been modified. It's undergone some major changes. The significant one in this instance is the format has been shifted. And it's not super significant, but maybe it's helpful. Format of the agent duties and the buyer's duties have been modified to hopefully make them more clear. Essentially, they've been parceled out into numerical lists. What agents does the seller, the agent, what things does the agent provide to the buyer? They provide these various 5 agent duties. What things does the buyer provide to the agent? These various 8 things are true. The buyer will cooperate. They won't interfere. These haven't been changed. There was no buyer duty or agent duty that has been added, but rather, instead, it's just clearer, hopefully easier to read. Per the settlement, the buyer is not allowed to accept compensation that is in an amount greater than the amount established in the buyer representation agreement. That's been added to the buyer rep agreement. This is a pretty significant shift because it's something that the market has never dealt with until basically now. Agent, this line's 87, 88. Agent may not accept total compensation payments from all sources in excess of compensation agreed to in Section 8 and under Oregon law, ORS 696-290, it's the commission sharing rule. Agent may not rebate excess compensation to the buyer. That's the significant change to this form itself. I see one thing in chat as well about the early termination fee and X amount. Why is it not X amount, but in no event more than 25%? It's a good question, but the reason why we just have 25% there is because it was in the middle zone. The DeTomasi Motorcycles versus Moak Realty case basically said we don't know what a liquid damages fee is that's bad, but 40% is probably bad and 10% is pretty good. And so all we really know is that 25% is kind of in between the two spaces where the court officially says bad, 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 and where the court officially says that's totally acceptable and fine. Theoretically, we could have set early termination fee up to 2% or 1% or something like that and put it really low and just guaranteed compliance. But 25% was in kind of a safe middle zone between those numbers, and that's why it was put where it was. Back to 9.4, so that was the change. The next change that we've got in this is 9.4a, and it's a new document. It's a new amendment form. This one is, when we do these like 9.4a or 9.3a, the A documents, they are a sister compendium document that just goes with the primary one. So 9.4a is not an amendment to anything else in the library except 9.4. That's the only thing it modifies. 9.3a, the only thing it modifies is the listing agreement, 9.3. And so when we put it there, it's just essentially, so on zip forms, it's right next to the other document, so it's right there in line. But just be aware, this is an amendment that modifies one specific document. 9.4 is modified by 9.4a. And what it allows you to do is modify various portions of the buyer representation agreement. The purpose of this document is to modify the exclusive agency agreement, the agency relationship between the buyer and the agent. So the buyer representation agreement can get modified with this. Upon mutual acceptance of this amendment by buyer and agent, the terms of the amendment are made a part of the buyer representation agreement. It's an amendment. To the extent that these terms conflict with terms in the original buyer representation agreement, the amendment controls. To the extent that these terms don't conflict, go back to the original language because the terms weren't conflicting. It is a pre-drafted amendment to the buyer representation agreement. Previously, you could do this with an amendment form, just 9.9, just slap it in there and say the buyer agreement is changing in the following ways. We've pre-drafted it for some of the major changes that will happen to your buyer representation agreement. For example, you're modifying the term. The parties agree to make the following changes to the buyer rep agreement. We're modifying the term. The buyer rep agreement now ends, at 5 p.m. on the following date or upon the successful completion of the objective. What this allows you to do in theory is to set up a short-term buyer representation agreement for a showing. Say, I'm your buyer representation, representative agent for the next 48 hours until July 12th at 5 p.m. I am your agent. And if you like it, if you like my services, we can use this document and modify it so that I'm your agent to a full-term representation amount, until December or whatever it ends up being, however long you're representing them. But essentially, it streamlines the modification. It allows you to more easily do something where you say, here's my buyer rep agreement. I'm only your agent for the next 48 hours to show you houses. That's all you want to do. That's all we have to do. And if we want to modify it, there's a super fast, easy form to do that change to make this a real, like, full-on buyer representative agreement. You can modify the purpose and the objective, similar to that thing where you're shifting from like showing only or to a limited search. You can use this to broaden out the boundaries of your representation. The concept of a representation as an agent is you are supposed to be robustly representing your client to accomplish the purpose of which you were hired, for what you were hired to do. You are technically limited agents in the way that's described because you are not given a power of attorney. On the legal hotline, we did have a situation where a broker was made power of attorney of the client, and that was the wrong move. That creates a whole bunch of problems. Do not become your client's power of attorney when you're helping them buy a house. That is essentially the same thing as like shaving your head when you wanted a haircut. It is way more than you really wanted in most situations. If you have a limited representation agreement, limit it and be very clear about what you're doing. Client, I'm going to help you. I'm going to help you try and find a residential real estate property in the Lane County area. We're just going to look in Lane County. If you ever want to move elsewhere, if you want to look into other places, if you want to start looking in Benton County, or if you want to make a super big change and, I don't know, you go to Grants Pass or something like that, we can make a modification. We can change the scope, but just be aware, this is the scope of what I'm going to be doing. I'm not going to be showing you houses in Multnomah County if you're asking to look at houses in Benton County. We're just going to be looking within our own scope. Do note, this is an amendment that fully it replaces the modification of the purpose and objective section of the buyer representation agreement. So if, for example, you wanted to just add something, they say, I want to look in Marion County and Multnomah County, you would want to have this read Marion and Multnomah rather than just adding one in. You modify by replacing the whole thing rather than modify by making additions. So if you wanted to stay, if the client says, also, let's look elsewhere, this would now read your original language for your your objective. We're going to find a house in Marion County and in Multnomah County rather than just whatever addition is being brought on. You can modify compensation if need be. The buyer representation agreement compensation section can be modified. It can be set as a percentage of the gross sales price. It can be set as a flat fee, or you can do other. If it's something where you're suddenly on retainer or something like that, or you're paid hourly, you can make a modification to the compensation structure. You also have a space for other modifications. That one has no guardrails. Be cautious how you use it because we're basically just handing you the keys and saying drive safely. So just be aware. Super fast, easy way to modify your buyer representation agreement. 9.4a. Minor updates. There have been quite a few minor updates. These ones are not significant shifts, but they do kind of help with the process. The first is 2.16 and 2.17. Those are the buyer occupancy addendum and the seller occupancy addendum. The situation where you have a buyer who moves in before closing or a seller who stays on after closing. In those instances, you have kind of a tenant situation that's not under the Oregon Landlord-Tenant Act. ORS 90 doesn't apply if you're there for less than 90 days. And so stuff gets weird. And these agreements they kind of need to be in place. We made an addition to this where it now says if something goes wrong and the buyer, something is damaged on the property and the buyer representation agreement or the buyer occupancy thing, if the buyer damages seller-owned landscaping systems, components, all those things, and they are damaged during the buyer's occupancy, they're responsible. Similarly, the corollary is there for the seller's occupancy. If in the time the seller's living there after closing, they damage buyer-owned landscaping or components or systems, or those systems fail or are damaged during the seller's occupancy, the person living in the property is responsible. Basically, what it says is if you're moving into this house and you break stuff, you are responsible for that broken thing, for fixing it, because you're not guaranteed to close necessarily, and you might have a situation where a seller breaks something that is the belonging of the buyer, and the seller should be responsible for fixing that thing or for returning it to its original state. This had originally just stated replacement of any systems, components, or appliances that fail during the occupancy, and you get these awkward situations where a seller, tenant, or someone along those lines, like, I don't know, keys the window or the oven or something like that, and they cause damage to it, or they kick over a shrub in the backyard just out of anger or something like that. In those instances where they cause that damage, they're responsible for fixing it. That's been added into these documents. 4.2, 7.1, and 7.4. These are the investment property addendum, the tenant vacancy addendum, and the agricultural tenant addendum. These have been modified with the following addition in all of the documents. This little line that's in yellow: seller shall transfer all security deposits, prepaid accounts, and last month's rent to buyer at or before closing. That technically was required even without this line in there, but we put it in there so that people can read it and say this is in the contract, you knew about it. If you are a seller and you sell a property with a tenant inside it, and the tenant remains in the property past closing, such that you have to assign landlordship over to the new owner. You, the seller, used to be landlord, now the buyer is landlord for the next 60 days or something like that. The security deposit, the prepaid rent account, and the last month's rent, that moves with the landlordship. It should be moving that way. If you are a seller who received a security deposit, sell your house, and then run off with that security deposit, that's literally conversion. It's theft, because that money doesn't belong to you. It technically belongs to the tenant. It's like equitably held by the tenant under law. So if you're selling property and the buyer is becoming the new landlord, you under law already had to transfer these things. Now we're just making it very express and stating it because people had confusion on this one. Yes, you absolutely have to transfer the security deposit, the prepaid accounts, and the last month's rent. If you don't, you're breaking the law. So just be aware that that's now in all of these tenant assignment related documents. If a landlordship is moving hands, if one seller is no longer landlord and they're appointing the buyer as the landlord, now this language is present in those contracts. 5.3, 5.4, 5.5, 5.6. These are the termination documents: the seller and the buyer termination notice, the seller and the buyer response to termination. All of them have been updated with the following language: buyer's instructions to escrow / trust account holder. And it says buyer will instruct escrow / trust account holder to terminate the account associated with the sales agreement and distribute earnest money as follows. Originally, it had just said instructions to escrow, and it was buyer instructs escrow to terminate the account associated with sales agreement and such. And there are still some brokers that use client trust accounts. And so in those cases, they're like, well, shouldn't the parties be telling me where I send the money to? It just says escrow. I'm not escrow. Okay, now you're included. So everyone's got their name on the system. If you are still using client trust accounts rather than escrow, it now is instructions to you as the client trust account holder where the money should go. Minor update to 9.5, 9.6. The indemnity provision was consolidated. Originally, this had been 4 subsections. We just combined 2 of them together, I believe, under subsection 2. That used to be 2 separate things, and now they're just one all together. It doesn't change indemnity provision at all. It just makes it a smaller kind of, not 4 separate concepts, but 3 separate concepts. Not really a huge update, but it's important to note we didn't remove one of your indemnities. It's been kind of smushed into a smaller section of the contract. There has been language added to 9.6, just so we know this. That's the seller, non-represented seller and fee agreement document. It's what you do when you are a buyer's agent and the seller is unrepresented. That document has been updated, so it now says seller understands that seller may provide compensation to broker from transaction proceeds at seller's discretion, and the value of such compensation, if agreed below, will be subtracted from the buyer's ultimate payment obligation to the broker. Basically saying, hey, seller, if you really want to, you can pay the agent. I know you're not represented by them, but you might want to, and you can. And if you do, it's going to be subtracted from the amount the buyer owes their agent. And then we also say this compensation is not required, it's not fixed, it's not recommended, nobody's telling you to do this, it's an option available to you. And so in this instance, where if you do have a seller that's like, yeah, I would love to be the one that pays the agent for the helping on these services, or I want to contribute some portion to this, this allows them to still proceed with that without violating the settlement terms. It's essentially a mainlining in the same thing that you do with Form 2.24 previously, and what you now do on Section 4 of the agreement, where you say sellers providing X number of dollars to the buyer's agent. It just mainlines that into the unrepresented party agreement as well. If the seller does so choose, they can fill it out. Similar thing was added in the buyer unrepresented buyer thing, which is essentially that the compensation to the agent is discretionary, and technically the buyer agent can provide money if they need to, but they don't. There is a minor update to 10.1 and 10.2. These are the advisories: the buyer advisory and the seller advisory. 10.1 is buyer, 10.2 is seller. All of the links within it, the HTTP hyperlink, HTML links, they've been updated so that they no longer just read "click here" and instead are a searchable term, where if you Google this term, you can find the document. So if the link fails for whatever reason, you can just Google that and it'll get you to the document you're looking for. So here, for example, the average prime rate offer is available online at Federal Financial Institutions Examination Council's average prime rate offers webpage. If you click that, it'll take you to the average prime rate offers webpage. If you Google Federal Financial Institutions Examination Council's average prime rate offer rates webpage, you'll get the exact same page. So the idea here is, rather than kind of leaving you in the dark and saying click here, and if you've got a document, you're like, great, I can't click on a paper, so what's this do for me? You now have guided information that will still take you to the same source, same document. Hopefully that makes it more usable for people that aren't doing this on their computers all the time. The other thing that's been updated in those advisories is references to Form 2.24 have been removed, and some formatting has been updated to make it more consistent throughout the document. So hopefully it's slightly more readable, and also it doesn't reference 2.24 anymore. Lastly, this is the minor fix that happened to a whole bunch of documents. Basically, any document where there was a signature and a requirement that there be mutuality in the agreement, the language has been updated to reflect that effective date is when the addendum is mutually accepted, not just when it's signed. The original language is, by signing below, the parties agree to the terms of this addendum and make it part of the above referenced sales agreement. The problem is, a lot of people were signing these documents and then hanging on to them for several days and then sending them over. So I send you a repair addendum, you sign it, several days pass, you send it back to me and you say, ah ha ha, I know it technically lapsed and my repair addendum period is over, but I signed the document while we were still under contract, and I was just holding on to it, and you didn't know about it, but now it's a valid thing upon signature, right? Because that's what it says. That's kind of a trite way of understanding the law of it, because mutual assent is required to form contracts, and technically you would fail in a court of law if you made that argument, but we just mainlined it into the contract. Now it says, by mutually accepting the above terms, and mutual acceptance in the contract is defined, and the sales agreement is defined as when you sign it and send it back to the other party. When both parties have both signed and sent the document to the other guy, now you have mutual assent, mutual agreement. The parties agree to the terms of this addendum and make it part of the above referenced sales agreement. So delivery is now required to make your addendums valid, enforceable pieces of the contract. It's not technically a new thing. It's more a restatement of the way the law already was, because some people had a misguided understanding of it that was creating problems. We also capitalized the word addendum because it's technically reference to a specific addendum, so it's a proper noun that needed capitalization. That was the change that was made to most of the documents in the library, many of them, like 2.1, 2.2, 2.3, and so on and so forth. Through most of the library, this change has been made. It's not a change in the practice. It's not a change in the law. It's just a more straightforward explanation, or at least a more direct explanation of the fact that signature alone does not a contract make. And that's what I've got. Are there questions? We had a handful in there earlier. I think I got to most of them that popped up as we went. But if there are questions, now is a good time. If there are no questions, that's what we got. So I release you back into the world. Enjoy your hot day. Hopefully It's not super, super hot out there wherever you are. As people are leaving, I think it's a good time for me to plug as well. If you do have comments about the forums, we absolutely advise that you guys provide those comments to us. They are what it is the fuel that allows us to make proper changes to the forums that are kind of helpful to the industry. So forums at OregonRealtors.org is a great place to go. If you look on orforums.org, the website, you can provide us with various commentary on the forums or questions, or just tell us that you don't like them and they look bad. That's fine too. But we like having as much commentary as possible because that's what we can operate on, and we can basically we can respond in places where your expertise is greater than ours. Looks like what we've got, Katie. If you want to shut it down.
Thanks, Nick. Have a good afternoon, everyone.